Moving on from the discussion of the meaning and definitions of human rights, the question of state responsibility is the subject of this video lecture. Here we discuss the consequences of Article 1, an International Law Commission's article on state responsibility, which was presented to the United Nations General Assembly in 2001, which states, "Every internationally wrongful act of a state entails the international responsibility of that state." So we're here to ask, when does a state commit an internationally wrongful act, and what does responsibility mean? In some cases, establishing state responsibility is easy, but in other instances much more difficult, especially when a state acts outside of its own territory or when domestic policies have negative human rights consequences for those living in other countries. How responsibility is envisioned varies according to state and according to international organizations and treaties. But one way to think about them is to think, as we have in previous discussions, in terms of negative and positive obligations. This is something that several cases provide examples of and legal guidance on. Negative obligations include, above all, the duty not to harm others. These are universal for individuals and states. The United Kingdom cannot torture British subjects, but it also can't torture any individual. Important landmark decisions in international organizations and international courts establish the boundaries for interpreting negative obligations. For example, Lopez Burgos v. Uruguay establishes that a state's actions taken outside of its own territorial jurisdiction can be considered human rights abuses, contrary to Uruguay's claim that the kidnapping and murder of Lopez Burgos by European agents occurring in another country meant that the state held no responsibility. As the Human Rights Committee in the UN argued, while Article 2 of the Political Covenant argues that each state party undertakes to respect and to ensure all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant, nothing in that covenant can be read to permit states to perpetuate violations in another state. The United States was following a similar logic that Uruguay was using when it housed enemy combatants in Guantanamo Bay rather than some site in the United States. However, in other situations, other entities than the state or more than one state is involved, or when one state clearly commits human rights abuses, but it is not under a treaty, so they are not responsible. In Suring versus the United Kingdom, the European Court of Human Rights found that English authorities could not follow an extradition order from the United States. This was when a German man was accused of a double murder in Virginia and was arrested in the United Kingdom. The court found that if Suring returned to Virginia, he would likely face the death penalty, and the court held that constituted a violation of Article 3 of the European Convention, which prohibits the death penalty. The position of the British government was that it did not bear responsibility for what happened to Suring once he was back in the United States. The court rejected this and held that extradition under circumstances where torture and degrading treatment might take place violated the spirit and intention of Article 3 and the European Convention more broadly. In Bosnia versus Serbia in 2007, the International Court of Justice ruled that Serbia was not responsible for genocide by providing massive political, economic, and military assistance to Bosnian Serb military forces, and they were trying to convict them under the Genocide Convention in Article 1. The ICJ ruled that Serbia has not met its obligation to prevent genocide, but because of its failures to arrest war criminals, but it was not responsible for the genocide itself. The ICJ set forth a standard that in order to be responsible for the outcomes, the sending state must control virtually all of the activities of the recipient, but also it must have been aware that the intent was to commit genocide with the aid received. Finally, in Bankovic et al. V. Belgium et al., the question was whether a NATO bombing mission over Serbia in 1999 that killed 32 civilians could be assigned responsibility to the European states. The court found that there was no jurisdiction because the event occurred outside of European borders. Confusingly, the court had found differently in previous decisions. The same court had ruled, for example, that Turkey was unlawfully occupying Cyprus. The court argued that the European Convention only reaches outside of Europe when the state in question has effective control over individuals in the other countries. The main takeaways are that authorities cannot do things prohibited in their home country in another country. Authorities also cannot place an individual in a situation where he will have his rights violated in another country, and there is a very high standard for responsibility for the commission of genocide, but a high standard also for the state responsibility to prevent genocide. Negative and positive obligations present two major differences. Negative obligations cover civil and political rights and are universal. Positive obligations cover economic, social, and cultural rights and are not universal, but rather referred to as requiring, quote, full coverage and a specific division of labor among, quote, duty bearers. All negative obligations fall on everyone. In other words, we have to avoid hurting one another. But positive duties need to be divided and assigned in some reasonable way, taking into account the limitations of duties on any one individual or any one state. Because without limits, this would lead to violations of rights of the person or the state who bears the duty. Under the International Covenant on Economic, Social, and Cultural Rights, Article 2:1, states must individually and through international assistance and cooperation take steps to achieve the full realization of the rights recognized in the covenant. Economic rights are different from political rights because economic rights do not demand immediate results. Poor states cannot be expected to provide the highest attainable standard of health care, for example, to its population. So states have some flexibility related to these obligations, but large numbers of states fail to meet the obligation. One example is Mugabe's government in 2000 and 2001. They instituted a land reform program that caused a decline of maize production right before a major drought. These two events made half the country food insecure, and rather than seeking international assistance, the Zimbabwean government placed restrictions on food aid to the country and denied foodstuffs to their political opponents. Even without these actions, Mugabe's failure to pursue all channels to provide food to Zimbabweans qualifies him as responsible for human rights violations. But what about extraterritorial obligations to other states? In other words, many Western states believe that they do not have any such obligations. However, the Economic Covenant does not have any clauses about territory or jurisdiction, and the language is clear that states obligate themselves to provide, quote, international assistance and cooperation in order to achieve full realization of the rights listed in the covenant. However, a growing number of diplomats within the UN organs hold that human rights obligations extend beyond borders, and this includes economic rights. The domestic political side of this, however, reflects a disconnect with reality in the United States. In 1995, respondents in a study of public attitudes at the University of Maryland found that 3/4 of respondents thought foreign aid was too high. When asked how much was spent on foreign aid, the median response was 15%. When asked what the right amount should be, the median response was 5% of the federal budget. In 2001, the median response was that 20% of the federal budget went to foreign aid. It is actually less than 1% in the time period under this study. The UN target for official development assistance is 7% of gross national income. The figures reported in the bar chart show that the country average official development assistance in 2007 was 4.5% of the gross national income. The United States contributed 1.6. The ECOSOC Committee, the Economic, Social, and Cultural Rights Committee, continually champions the idea of extraterritorial responsibility, placing more responsibility on the economically developed states than others to provide international assistance through individual, state, and cooperative efforts. A lot of these emphases are found in general comments and special reports, as well as concluding observations. In essence, the United Nations approach in the 2000s has strongly advocated the view that states possess positive as well as negative obligations. Moving on to contested obligations, which represent several obligations that states have been resistant to accept, or responsibilities. So among these, civil and political rights are sometimes given the greater emphasis because it's much easier to spot when a state is not in compliance of the political covenant. This does not mean that economic violations are less deadly, though. If you compare, for example, the number of Iraqi deaths that result from economic sanctions to the number resulting from the ongoing conflict, both actually are highly consequential and in the hundreds of thousands. One of the first areas of contested responsibility lies around the issue of arms sales. When a country provides weapons to another country and they use those weapons to violate human rights, can the sending country be considered responsible? With the exception of China, the other permanent members of the United Nations Security Council were the biggest arms dealers in the world. Most countries have some human rights conditionality in their export laws, but this has not stopped countries from exporting to them. One study found that 9 of 35 countries to which the U.S. sold weapons were either experiencing a military conflict or were classified as not free or partly free in the Freedom House report. The number for Russia was 9, 12 for France, 5 for Germany, 9 for the UK, 10 for the Ukraine, 9 for Italy, 5 for China, 6 for the Netherlands, and 3 for Canada. The present approach in international organizations is to assign no responsibility. The second area of contested responsibility relates to extraordinary rendition. In the usual practice, extraordinary rendition occurs when an individual is kidnapped in one state, flown to one or more other countries, interrogated, tortured, in a country like Egypt, Syria, Thailand, or Pakistan. One of the famous examples involved Maher Arar, a Canadian national taken off a plane at JFK Airport in New York, subjected to nearly 2 weeks of questioning by U.S. agents, flown to Italy, then Jordan, and eventually to Syria, where he was detained for more than a year and tortured repeatedly. The Canadian government exonerated him of any wrongdoing. He won a $10 million settlement. But when Arar sued for the torture inflicted on him, the Ontario Superior Court dismissed the case on the basis of sovereign immunity. The U.S. government has kept the man on a terror watch list and has not offered an apology. Arar has filed suit in the U.S. federal court against various officials, but the case was dismissed on the basis that any litigation would reveal state secrets. His appeals failed, and the Supreme Court denied the case a hearing. So who was actually responsible? The United States, Italy, Jordan, or Syria? Among the economic, social, and cultural rights, one of the most contested responsibilities relates to the global gag rule. This is also known as the Mexico City policy, and this was an executive order under George W. Bush in 2001. It revived Reagan-era restrictions on aid that promoted or advocated abortion. After the issuance of the gag rule in Kenya, which could only afford about $6.20 per person in healthcare spending, in spite of spending 17.6% of its GDP on healthcare, they had to reduce services operating their country because of this rule. This led to severe shortfalls in healthcare and healthcare provision because of the closure of clinics that would not adopt this rule. Kenya is a signatory to the Economic Covenant, as well as the Convention to End All Forms of Discrimination Against Women, and both of these spell out the country's obligations to protect the right of everyone to the highest attainable standard of physical and mental health. So Kenya obviously felt they could not, under the restrictions of the gag rule to not provide abortions, felt like they would be violating their rights to their citizens. So while Kenya was certainly responsible for the failing health care outcomes, some might argue that the United States had played a hand in strong-arming the closure of these clinics. This led to reduced health care outcomes, and nonetheless, the current international approach holds that the United States is not responsible, in spite of the cause and effect relationship observed. That's because they're not signatories to the Economic Covenant or to the Convention to End All Forms of Discrimination Against Women. Another example relates to the distortion of world market prices, the impact of overproduction of sugar due to subsidies in European countries, which has had negative impacts on southern sugar farmers. Not only are the southern farmers not able to compete internationally because Europeans can farm cheaper with government subsidies, they are not able to compete locally because the Europeans engage in a practice known as dumping, where they flood the local markets with excess product, making it impossible for local sellers and producers to have any part of the market. All 25 member states are party to the Economic Covenant, and it is argued that they are in violation because sugar dumping denies farmers in the South an adequate living. A Canadian company's mining operations' environmental destruction is the last subject. So an island in the Philippines was the site of a mining project run by a Canadian mining company, and members of the community traveled to Canada to testify before the Parliament about the environmental degradation of their community. And this committee wanted stricter regulations on foreign operations, but the government tabled the measure and rejected many of the recommendations of the subcommittee and lowered the standards for how corporations could behave in Canada. Most countries do not have environmental laws for their corporations to follow in other countries, and this can lead to environmental as well as labor rights degradation. Obviously, home states have some responsibility in situations like this, but other scholars and diplomats call for a stricter reading of the responsibility to include powerful countries with consequential power over the developing states to hold some responsibility for environmental degradation.